Okay, so it's time to stop cussing.
No, it's okay, because we've learned that irreverence is good for our audience.
All right.
Although we don't have an explicit rating, so I'd have to beep you. But that would be okay.
All
right, so I'm sorry.
On any given day, that might actually be fun.
Welcome to the Three Wise Men of Divorce, Money, Psych, and Law podcast. Sit down with the California divorce experts, financial divorce consultant Mark Hill, marriage and family therapist Pete Russos, and attorney Shawn Weber for a frank and casual conversation about divorce, separation, co-parenting, and the difficult decisions real people like you face during these tough times. We know that if you are looking at divorce or separation, it can be scary and overwhelming. With combined experience of over 60 years of divorce and conflict management, we are here for you and look forward to helping by sharing our unique ideas, thoughts, and perspectives on divorce, separation, and co-parenting. All right, gentlemen, we're here again for another year, and we have a guest with us today. A good friend of mine, and I know of yours as well, Mark and Pete, Dr. Robert Simon. Robert, it's good to have you.
Thank you. It's good to be here and good to be with the three of you.
So how long have we known each other, Robert? I think it all the way back to 2003, I want to say. Has it been that long? Has it been 20 years?
I think probably close to.
Yeah.
You were newly out of law school, and very fresh and quite, enthusiastic and getting ready to begin your career and do good things. And look what happened. Yeah, well, but you're a forensic psychologist and a family law consultant in complex family law cases, and right.
You've become well known in this regard, with a international reputation. I've been impressed just kind of watching your career as you've shared your knowledge with others, and you and I worked closely together back in a previous life when I used to litigate. You actually helped me win cases.
Yeah, we did some good and probably destructive work together.
Well, it's interesting, that last case that we were on, I think you might remember it. It was a move away, and you sat second chair. That was one of the cases we won, but then the outcome was not good for the family when it was all said and done.
What was that? Winning the battle and losing the war?
Yeah.
If the war was the well-being of the family and the people in the family.
Yeah, it was one of those cases that made me think, I don't want to litigate anymore because I noticed the destruction that it causes.
Yeah. Right.
And but you have done a good job over the years I always think you do a good job of keeping forensic psychologists honest. You make sure they follow the procedures and follow the rules.
Shawn, I think a lot of the work I do in litigation, which I do with some ambivalence, because I think litigation can be so toxic to families, particularly custody litigation.
Yeah.
I think when it's going to be done, it needs to be done as cleanly and as civilized a way as it can. And I think that when experts come in, people like me come in and advise the court about what they believe is in the best interest of children, I think it's really important that the court gets the kind of input that's high quality input. And so a lot of what I do when I consult on cases and when I do get involved in litigation in the here and now is to make sure, or try to make sure, that the case plan is as child and family centric as it can be, that it does no unnecessary damage, and that if the court has, say, appointed a child custody evaluator or an expert to advise the court, that the work of that person is presented to the court in a fashion that makes it clear what's good about the work and what's weak about the work.
Mm-hmm. So what should people expect? I mean, we've got a lot of people in our audience that might be facing a forensic psychological custody evaluation or something to that effect. What should they expect? What should they be prepared for?
Can I tweak the question a little bit? I'm curious.
Yeah, please.
Maybe even more elementally, what is a custody evaluation,
Thank you.
why do they happen? Why are they necessary?
Excellent question. Sometimes the simple, basic questions really need to be asked, and they need to be asked a lot. So a custody evaluation is a psychological assessment process of a whole family. It's what we call a forensically informed process. The evaluator is not doing clinical work. They're not being a therapist. They're not there to actively help the family solve problems. They're there actually to gather information about the family, about the children, about the parents, formulate a sense of a parenting plan, a child sharing plan, and any ancillary or auxiliary services that the family may need that support the best interest of the children, and present that to the court. That's what a custody evaluation essentially is. And it is used in cases where the court needs more information, more complex information, more detailed information, more nuanced information than it can readily get through testimony and things like that. The courts have limited time. Judges are not mental health experts. They sometimes feel that they need the input of a competent, specially trained type of mental health professional. And so we do these evaluations. In California, the rules for these evaluations are spelled out in our rules of court and our family code. There are various guidelines promulgated by professional organizations that advise how these should be done and things like that. Now, a custody evaluation, thankfully, is not needed in every child custody case. Where they're needed is in cases where the nature of the conflict between the parents is such that the court feels it needs more complex information, often of a psychological nature. Psychological functioning of the parties, parents' understanding of children's needs, of their ability to meet those needs. Sometimes there are concerns about mental health issues in parents, or drug and alcohol abuse in parents, or abusive, neglectful kinds of parenting practices. Or what I see a lot of is where the real problem may not necessarily be with mom or dad, but with the relationship between them, where the parents are involved in such a toxic dynamic with one another that they wouldn't be able to agree with each other, for example, that today is Tuesday. And by the way, we're recording this on a Tuesday. So, and in situations like that, the courts will sometimes use an evaluation. Now, in my experience, it can happen fairly often that the courts will decide to use a custody evaluation when they've exhausted other methods, or when the judge just feels frustrated and bereft and doesn't quite know what the heck else to do. And so they kick it over to someone like me. And they say, you advise me about what I should do. Now, what the evaluator does is to make recommendations. We don't make the order. Judge still does that. Does that help to answer your question, Pete?
It does, Robert. As you were talking, I had this thought that most people, I think of a child custody evaluation as being an adversarial process. Do you see it that way?
Yes, it is. It's very much an adversarial process in that mom tries to tell us all the things about dad that's not good. Dad tries to tell us all the things about moms that's not good. The ways in which their co-parent is being hard to get along with, is making mistakes with the children, is using poor judgment in their own lives, is drinking too much, smoking too much weed, whatever it happens to be. So it becomes very adversarial. And let's remember that a custody evaluation is ordered in the context of usually a hotly litigated child custody case, which is by definition highly adversarial. Because I've had the opportunity to be involved in divorces on a wider basis, in other words, be a part of helping the parties negotiate, for example, the property issues. I will tell you that there's nothing as divisive as litigating about children. Litigating about money or property or things can be tense and difficult, but it is child's play, and forgive the metaphor, compared to litigating about custody. That it's a blood sport it can become a blood sport for parents. And I want to say something that might be controversial, but I believe it's true. And that is that often the level of conflict between the parents is jacked up by the people advising them. Who are those people? Their friends, their family, and their attorneys.
That is so true. I've seen a lot of folks, I used to litigate, people would say, well, I want to get a psychological evaluation because it's going to show that my ex-spouse, he's got this wrong with him or she's got that wrong with her. And I used to tell people, you got to be careful about that because, you might get what you want. You might get a forensic evaluation, and then that's a double-edged sword sometimes.
Well, you think about it this way, Mother Teresa doesn't usually marry Attila the Hun. Or as one of my friends says, ones don't marry tens and tens don't marry ones. So if mom thinks that dad is all of this, the chances are that mom's got a little of that too. Here's the deal. In general, I will tell you, after doing this work for nearly 40 years, and having been involved in literally thousands of cases, either as a consultant or as an evaluator, the greatest risk to children when their parents split up is the conflict between the parents. Aside from abuse, neglect, and really, really bad parenting, right? The greatest risk to children is conflict between the parents about the children into which they're drawn. That's the bullseye. And in a child custody case that gets an evaluation, it's more likely than not that they're at the bullseye. So the issue's not the issue, as our friend Bill Eddy says. There really is no winning, because what happens is if, say, dad wins, that is to say, the evaluator sees things more through dad's lens than mom's lens, or believes dad should have the majority of custody time, or whatever, dad should be able to move with the kids, whatever it happens to be. In these high conflict relationships between moms and dads, now that mom's been beaten, it's time to even the score. So round one almost always gives way to round two, which gives way to round three until the kids age out or tell both their parents to pound sand. So I'm not telling you that there's no place for child custody evaluations. I've been lucky enough to do cases over the years where there are certain non-negotiable issues, like, for example, a couple divorces. Let's say dad is in the military and they've been living in our hometown of San Diego, but dad now, as a Marine or a Navy person, because that's who we have in San Diego, gets a billet and has to move to another location. That can be an unresolvable dilemma that doesn't necessarily only take place in the context of a couple that's had high conflict. It's a circumstance that comes about and has to be resolved. And they may not be able to resolve it. And an evaluation can be, in that sense, helpful and not highly, highly divisive if, in the run-up to the evaluation, the peanut gallery, friends, family, attorneys, keep it civilized. But for the most part, custody evaluations aren't that way. They are evaluations done on the minority of families that, again, as I said before, where the parents won't agree that today is Tuesday.
Mhm.
One
Okay.
thing that occurred to me as I've been listening to you, Robert, is that, I'm the financial guy, so I'm trying to put a financial slant on this as we go through it. And the one thing that occurs to me is that the issue sometimes comes down because the amount of time with a parent has an impact on child support.
It can.
And we've talked many times when we've tried to go to alternative dispute resolution about the problems with buying and selling children in negotiations in divorce. How often is it a financial motivation that you see driving this? Because I remember a case I did years ago where the dad wanted 50-50, but the minute he got the kids, he would hire a babysitter and go out with his girlfriend. So again, that was a financial motivation.
From my perspective, from my vantage point, let me say, I rarely know whether there's a financial motive because let me put it to you this way, Mark. If mom says to me, I want to go from 60-40 to 70-30 because I need a couple extra $1,000 a month, she's just done herself in, right? Now I know that her motive is not exactly what you might want to call child-centered, and it's unlikely things go well for her. And most people have the common sense not to tell us that, and their attorneys tell them that. And we, as evaluators, don't deal with the money. So I don't often know that for certain. I can smell it sometimes, right? I can sniff it, but in advising the court, if it gets there, I can't tell them that I think that's what's going on because I'm not going to be collecting data about that. If somebody tells me that and it comes to me, I can use it, but I'm not going to say to a parent how much of your motivation is financial.
Understood.
Yeah, but I think the financial motivation is in the background. And for me, in my experience, is in the background in a minority of cases, but a substantial minority. What's more in the foreground are desires to vanquish the other parent. Mm-hmm. I'm right, you're wrong. Mm-hmm. And here's what happens. So, look, I mean, even when parents are married, even when parents are successfully married, they will disagree about parenting, won't they? If somebody says it's okay for the kids to see this kind of a movie, the other parent says, I'm not comfortable with it, or these are friends I'm not okay with, I'm okay with those friends, or, these things like that. So parents, because they're successfully married, don't necessarily agree about parenting anyway. When they separate, those differences become exaggerated. And what begins to happen as the adversarial mindset between the parents develops is that they will view the differences between them through a negative lens versus we're just different. Okay? I like to tell parents, if you look at a normal bell-shaped curve, that plus or minus 2 standard deviations from the mean is normal parenting. Okay? And if you know the bell-shaped curve, the plus or minus the third standard deviation is a very small percentage. So if I've got a parent at plus 2 standard deviations and I've got one at minus 2 standard deviations, they are both still in the normal range, but they're separate. Subjectively, they're very, very far apart. And what they tend to do then is take a very negative view of what the other person's doing, or what we see a lot, and I know all of you do too. If an event happens, say in the home of a parent, and the other parent doesn't have complete information about it, they will assume the worst. Mm-hmm. And the assumption morphs into a fact. And then the level of conflict, the nature of weapons that are used in this war escalates. So this is part of what I've learned over my many years of doing this work. And more recently in my career, as I've gotten older and perhaps certainly don't have the taste for the battle, but also have become much more alert to the negative consequences of the family. I try to instead of using my skills in a manner that divides a family, I try to use my skills in a manner that at least tries to establish even small areas of common ground. We can grow that.
So, Robert, I've heard so many clients say to me, I'd be better off in front of a judge. As soon as they hear the terrible things he/she did, I know I'm going to get everything I want. Well, how would you respond to a client that speaks in those terms?
Bull pucky. And by the way, if we weren't being recorded, I would put it more.
We can bleep you.
And let me tell you why I say that. It's not because I don't think judges are earnest, sincere, compassionate men and women. I believe that the vast majority of our judicial officers deeply care. But there's a number of things going on here. Let me start with the biggest one. The judge doesn't know these children. The judge doesn't love the children. Okay? The judge cares about the children in an abstract way, the same way that any of us do. But if the train comes and we're all on the railroad track, I'll push my kid out of the way, but I ain't pushing your kid out of the way. I'm running to save my own backside, right? So the judge is a stranger in a black robe, doing the best he or she can with very limited information to make the kinds of decisions that parents with a lot more information struggle with. Also, let's remember our court system is underfunded, desperately underfunded, and under-resourced. They do not have the time, the knowledge, the personnel, the bandwidth to deeply consider the nature of what's going on that is involved in these decisions. And then finally is this one. This is really what tipped me over in terms of my becoming much more committed to this peacemaking model that I'm using now, is that when we give to others the ability to make the decisions that are properly ours to make, when we ask a judge to essentially make parenting decisions, we give up our efficacy. We give up our power. We give up our sense of can-do. And to a system which is is a thing. It's not even an organism that's alive. It's a thing. It's a governmental entity. We give up our sense of efficacy. We give up our sense of personal power. We give up our sense of being able to make the kinds of choices that parents want to be able to make about their kids to a system. And the more we do that, the more we believe in our powerlessness, the more frustrated we become, the more likely that frustration spills over into conflict. It's a self-perpetuating cycle.
That's so true what you're saying. You know, I've served as a privately compensated temporary judge before on a few custody cases, and I found that what happens is I get if it's not clear what the facts are, you get frustrated and then you get angry with the parties.
Yeah.
It's just a normal human reaction. And I found myself being very angry at people, which I think is what happens to these judges when they get these cases and the facts aren't clear. It's a he said, she said kind of a thing. And the initial reaction is pox on both of your houses.
Or let me just split the difference.
Sure.
A little over here, a little over there. Look, The four of us, I know that the four of us are all fathers. We're all parents. Some of us are actively raising children now. Some of us are retired from actively raising children. Me being one of those.
You never retire.
Actively raising children, Mark.
Yes.
The way I like to say it is the kids are on their own and the bank of dad is closed, at least mostly closed.
My father once said, children grow up, but they don't always grow away.
There you go. There you go. And, if you think about when you're raising your own children, how certain decisions that need to be made, decisions that have some gravity to them, are really hard to make. And you have a lot more information, a lot more knowledge about who your child is and what's going on in their lives, you hope, The judge has a grain of sand on the beach amount of knowledge compared to what you have, and is having to make these decisions about somebody else's child. Okay? And let's remember this too about the judge. The judge is human, so the judge is not perfect.
Yep.
And the judge may not feel well that day. The judge may have had an argument with his or her spouse that morning, or maybe having some other personal issues that week that are affecting their presence, their attention, their mindset, their even their sense of how happy they are to be doing their job, right? And so when somebody says, "I'm just going to go take a chance with a judge," I remember growing up and thinking that judges somehow were these omniscient, more perfect people than we are. I've gotten to know, as we all have, many, many judges over the year. They are every bit as flawed as everybody else. They just happen to be given a title called judge. But omniscience is not a part of their job description any more than it is for any of us. As a custody evaluator, in some ways, people see me as the quasi-judge. I'm going to be advising the judge, right? And what I tell them is, you're going to have an imperfect person do an imperfect evaluation and present it to an imperfect judge. Okay? That's 1, 2, 3 strikes. How many does it take to be out? So when people want to do, when families want to do a custody evaluation, I'm always careful to try to educate them about the realities of it so that their expectations are realistic. It's another method to getting to an outcome, but it is by no means magical, perfect, and we psychologists that do them are only human beings. And none of us have absolutely flawless skill sets. We all make mistakes every time, every case.
Robert, it sounds like the model that you've developed, one of your goals is to create a more collaborative child custody process, is what it sounds like.
Yes.
So I wondered if you could speak to what does it take for a child evaluation, custody evaluation process to be more collaborative? And I'm thinking about how that gets incorporated into the work that Shawn and Mark and I are doing vis-a-vis non-adversarial family law settlement, disputes.
Yeah. And so the way that the model that I want to say I've developed, but I am developing, and I say I am developing because it's a work in process. I'm learning, and other folks who are using this model are learning with each new case, and we're sharing what we learn and the mistakes that we're making, right? And the successes we're having, but mostly we learn from our mistakes. And it incorporates a consensual dispute resolution process into the evaluation. So the parties agree going in that after the evaluator has collected the data and formulated an analysis of what they think is likely a best interest set of recommendations, that the evaluator will sit down with parents and their lawyers, share that, and assist them in negotiating an outcome to the best of their ability. I call it consensual dispute resolution rather than mediation. And I'm a big believer in mediation because in the law, mediation has a very specific meaning. And it includes that nothing that takes place in mediation is, everything's confidential. Mm-hmm. Whereas during the consensual dispute resolution process, if I'm seeing a particular parent behave in a certain way towards their co-parent, or certain kinds of information come to light in that process that I think may be important to include in my database should I have to make recommendations, then I use that information. So it also keeps the parties earnest. Mm-hmm. They know that they can't go in there and behave poorly and not have that reflect on them potentially down the line. Mm-hmm. It also means that from the very beginning, the kinds of things I'm trying to learn about include not only the standard typical stuff that we learn in custody evaluation, but I'm trying to learn about how the parents see each other much more carefully, how they make decisions or don't make decisions together, and where there is common interest, common ground, and some overlap, albeit maybe there's overlap that they don't see that they have because they have got a different spin or color on it. And my job is to make it more mutual. So, but you have to pick your cases very carefully. There are certain issues that this kind of process is not suitable for. And there are certain lawyers who are not going to buy in because they want to go to court and litigate. That's what they're trained to do. That's what they believe is the path. And in some cases, the relationship between the two attorneys is so poor that part of what goes on, and folks, I want you to know that this does happen, that sometimes the conflict between the parents gets jacked up because the attorneys are trying to beat each other as opposed to really truly represent their client.
The story that comes to mind for me is I had a case, this is years ago when I was still taking court-ordered therapy cases, was I had I was seeing the mother in a case, and at what point I asked her, how long had their process been going and what it had cost them. Her legal bills at that point in time were $500,000.
Yeah.
They didn't have a light at the end of the tunnel. And it was a situation where the parties hated each other and the attorneys hated each other.
That's right.
And it was this perfect storm.
Well, Peter, when I hear you describe that kind of a situation, I just feel a combination of deep, deep sadness and rage. Because we, the professionals, shouldn't be a part of the problem. We should always try to be a part of the solution. And I've been involved in cases as a mediator where it's really clear that the mix isn't good. And I'm not the right person for the job. I got to get out because my presence is likely to make things worse, not better. Right? So I'm not getting along with one of the attorneys, or I don't like one of the attorneys, or one of the parents is rubbing me the wrong. You got to get out because it's not our job to make things worse. What we want to do is be the kind of people when we go camping that always leave the campground cleaner than when we found it. Right? I talk about it as being very, very aware of the footprint we leave on the family. The image I like to give people is the family is pronated on the ground on their stomachs, and we're just walking on their backs, and, maybe even wearing boots, and leaving these. And if you're wearing stiletto heels, you might be leaving a real impression. And we're walking on the backs of the family, leaving our footprints all over them. We don't often see ourselves as a part of the system, but we are. When we act on a family, we change the family, and we own a part of the change.
I think that's such a key point, Robert, because there's a certain level of emotional intelligence that you have to have when you're doing this work to be able to not become part of the problem, have that self-awareness, to be able to see, okay, I'm being triggered personally. I am becoming part of the problem. I am too enmeshed. And there's some attorneys out there and some psychologists, frankly, and some financial people that don't have that gene, if you will, to be able to be self-aware.
We're all people.
Right.
And we have egos. Some of us operate more from ego than others. We like to see ourselves as trying to benefit people. So it's hard for us to wrestle with the fact that sometimes what we're doing is actually harming.
Yeah.
Right. But the other thing is to recognize that no matter how skilled we are, we're never more powerful than the family. Ever. And so it's our job to always remind the family that we're here to facilitate a process, assist them in reaching their goals, but not take ownership of the outcome and not insist that it look a certain way. It's their decision. And at the end of the day, we can't make it for them. They'll ask us to, what should I do? What should I do? Tell me what to do and I'll do it. Then it's my decision. And these are your kids. No, thank you. Having done this work now for nearly 40 years and really feeling very grateful, deeply, deeply grateful for the career that I've had and the work that I've been blessed with by this universe to do, because I think that working with families and trying to impact the lives of children is calling. And again, it's a privilege. It's a privilege. We have to be mindful of our footprint on the family, and we have to be mindful that the tools we have are very few. And they're blunt tools. They're blunt tools. I mean, if I'm a forensic psychologist and I'm writing a parenting plan, and what the family needs is to have a splinter very carefully pulled out, all I really have is a rusty knife. Okay. And so we have to be careful about recognizing that our tools are few, they're crude, and that at the end of the day, if we can empower the family, now we've really done great work.
Can I ask, Shawn and Robert, you referenced a case that you worked where you said you won the battle but lost the war. And I'd like to hear more about how you're thinking about that.
It was one of those cases where, you feel really good as an attorney when you hear the judge quoting your trial brief in their statement of decision. I literally, with Robert's help, frankly, we won every issue. We overturned an evaluation that didn't go our client's way. And I remember there was a moment, Robert, when you and I were preparing for this and we were reading the evaluator's work and we were like, I wonder if they were right about this. They didn't have it wasn't sound forensically what they'd done. It was mostly hunches and things like that we got pretty good at attacking when they showed up at court. When you have a forensic show up at court with hunches, that's pretty easy to skew.
Even a broken clock is right twice a day, right?
Right. And so in this case, they were right. And what happened was, I don't want to say too much because then I might divulge the identity of the person, but we won. But that what ended up happening in the family dynamic was not good for this child in the long run.
I have a case that is pretty well known because it actually went up on appeal and made public law, where the question was, should the child relocate to Northern California with one of her parents or remain in Southern California with the other parent? And without going into a lot of the detail, I recommend the child stay in Southern California with one of her parents because the other parent was truly, wholly unsupportive of her relationship. The parent that wanted to relocate was completely unsupportive of the child's relationship with the parent that was staying here and had a history of this kind of what we call alienation with older children in the same family. So I made the recommendations I made. The kid remained in Southern California. What I missed completely was the fact that so the war was, the battle was won. The dad in this case won the battle. But the kid could not adjust to life in Southern California with her father because, as I understand it, mother kept jacking her up and agitating her and wouldn't let her settle in. Okay. And she had to therefore go and live with her mother in order to be able to kind of settle in and begin to live her life again, even though the way that the mother had handled the child's relationship with the father was problematic in my view. So that's an example of it.
Yeah.
You have the technically right outcome, but the holistically wrong outcome.
This
And
case
sometimes the I just got a ruling on a case today where I was an expert witness where in another state where the father had perpetrated all kinds of domestic violence and alienation against the mother involving two teenage boys. We proved all that up at trial, and the judge said, absolutely, you're right, but I'm leaving the kid with their father because they'll never settle in with their mother. Another example of winning the battle and losing the war. Yeah.
And sorry, Robert, go ahead.
And by the way, these stories are not unique to our four practices.
Right.
This, unfortunately, is an existential reality of families and divorce. And what I find is a lot of us that do this work, and we do it with our hearts, have real trouble getting our heads around the fact that those outcomes have to be left to be what they are. We didn't break it, and we just don't have the tools to fix it. It's too complicated. We don't know how to fix it. We don't.
Mm-hmm. Years ago, I had an attorney, back when I was routinely doing the collaborative divorce trainings, I had an attorney say that she got our invitation right after Christmas and it saved her career. She said just before Christmas, she had a court, her client won everything. She was elated. This was my greatest victory. She looked over at the husband, who was not her client. His hands are down in his face. He is crying. She looks to her client thinking she's going to see joy because they've won, and she's got the same result. Head in hands, crying, and she sees one of the adult children, obviously not involved in the custody dispute, but she sees one of them crying in the audience, one of the adults, and she's like, I have just hurt this family, winning my biggest victory. And when she got the invitation to the collaborative training, she said that was a light and a way out.
Yeah. That happens a lot. You know, there was that marvelous film, Marriage Story. Have you guys seen that with Adam Driver?
Sure. Yeah.
And one of the attorneys is patterned after one of our friends in L.A. But
actually, it was two L.A. attorneys it was patterned after.
Really? Was it the other one was patterned too? Huh? Okay.
Both the male and the female, yes.
Interesting. But there's the courtroom scene, I think, is so powerful, where you see these two parties sitting. You know, it's Scarlett Johansson and Adam Driver of the parents, and the attorneys are going at it, and you don't even see the judge hardly. You just hear these attorneys kind of going at it with each other, and you see it's marvelously portrayed how the parents are just becoming part of the furniture. They're not really, they've lost all their power. They're totally disempowered. And then there's a later scene where you see the two of them after the psychological evaluation has happened, where you see the father, played by Adam Driver, just completely melt down. And it's because these people completely lost their control, their power. I always tell people, stay in charge. You know, if you leave my office from a mediation and you have to go to a stranger in black robes, you're now no longer in charge.
Well, you lose your sense of personhood.
Yes.
You really do. You feel like and I've been through it. And I mean, as you all know, I've been divorced, and you know, the happy ending, my kid's mother and I now are very close friends.
That's great.
And, you know, it's, and my kids are in their 30s, and it's good for them still. Right. Mm-hmm. But, you know, I don't want to say that all court-based divorce litigation, custody litigation is bad, that it's a bad thing always, always, always. It's not always a bad thing. There are cases where the parents simply can't agree, and you've got to get somebody to call the balls and strikes. You've got to get to an outcome. Also, particularly in cases where there is a lot of psychological violence, something that we call coercive control, where a parent has essentially lost their sense of effectiveness in the world and efficacy, getting a very strong advocate to present their case in a court of law can be very empowering and healing for that parent. So, as is the case in almost everything on this earth, there are no absolutes.
That's absolutely true.
For most parents, for most people, divorcing, it is harder in some ways to do it in a business-like way, because it requires you to quash and take some of the hurt and the anger and that dynamic and process it elsewhere. I think about it this way. Sometimes, even when divorce feels like what you need or want, it's still a tearing and a ripping. It's a terrible, devastating loss. And often, in order to withstand the loss and go through what it takes to travel through that loss and get to the other side, what buoys you and keeps you from feeling completely crushed is your rage and your anger. It can make you feel a little bit more alive, a little more powerful, a little more animated. And so that anger is part and parcel of divorce, because anger is a part of coping with loss. And our job as family law professionals is to help people process that in a healthier way. But always remember, at the end of the day, that the clients are more powerful than we are. And if they're bound and determined to make a mess of it, they're going to.
Okay. Well, let's leave it at there. That's some good stuff. I think the moral of the story is there's no absolutes. Absolutely endorse that statement. You lose control if you go into court. Sometimes you have to, but if you can do it outside of court, that sounds like a better option. And it sounds like, when you're going into a situation where you're working with a forensic psychologist, what would you say is the last word for that, Robert?
Make sure that the forensic psychologist that you choose to have involved in your case recognizes the pluses and minuses of the legal system and their own limitations, and approaches it from a very human perspective first, and a technical perspective second.
Well said. Well, Robert, if somebody needed to get a hold of you, what should they do if they wanted to hire you?
They can email me, and they can call me. And I don't know how you guys handle that information in your podcast, but I'm certainly glad to provide that.
We'll definitely put a link to your website on our podcast description. Your website is dr-simon.com. That's dr-simon.com, correct?
That is correct.
Okay, great. And then, Mark, if somebody need to get a hold of you to work on a financial issue, what should they do?
Go to my website, actdivorce.com, EACDIVORCE.com.
And Pete, if they were to want to work with you, a licensed marriage and family therapist, as they're working through their divorce, what should they do?
And also through my website, which is peterroussos.com, peterroussos.com.
And if folks have a dispute that they need resolving, I'm the guy they should call. It's WeberDisputeResolution.com. Weber with one B, dispute like we had a fight, resolution like we solved it, .com.
Good. Gentlemen, thank you for including me in the podcast and the discussion today. I've really enjoyed just kind of, joining the three wise men today.
We're glad to have you along as a fourth wise man.
This is great.
Yeah,
Thank you, guys. Take care. Bye-bye.
Thank you. Bye-bye.
Thanks for listening to another episode of The Three Wise Men of Divorce: Money, Psych, and Law. If you like what you heard, be sure to subscribe, leave us a review, and share with others who may be in a similar place. Until next time, stay safe, healthy, and focused on a positive, bright future. This podcast is for informational purposes only. Every family law case is unique, so no legal, financial, or mental health advice is intended during this podcast. If you need help with your specific situation, feel free to schedule a time to speak with one of us for a personal consultation.